8 specific firearms are sitting in legal limbo right now, and one of them is probably in your safe. In March 2026, the Supreme Court made 2 completely opposite gun decisions on the same day, and neither one made the national headlines it deserved. State governments are acting fast while most gun owners are still asleep, and by the time the average person figures out what changed, it may already be too late. If you own a rifle, a shotgun, or even a standard handgun with certain modifications, this affects you directly, and you need to hear all of it before you load up the car, cross a state line, or pull that firearm out of storage. Let's start at the top, because the Supreme Court story is the one that nobody is framing correctly. On March 2nd, 2026, 2 completely different gun cases landed in front of the nation's highest court on the very same day. The first case is called United States versus Hamani. It involves a federal law that strips gun rights from people who use marijuana, even in states where marijuana is perfectly legal under state law. The justices were openly skeptical of the government's argument, which suggests the court may be preparing to loosen that restriction for cannabis users. That's potentially good news for millions of Americans. But on that exact same day, the Supreme Court declined to block a Maryland ruling that allows the state to take firearms away from anyone sentenced to more than 2 years in prison. 2 stories, same court, same day, one potentially expanding rights, one allowing restrictions to stand. That split tells you everything about how complicated this fight has become. Here's something crazy. The vast majority of gun owners watching right now have no idea this dual ruling even happened. And if you're not subscribed to this channel yet, you're one of them. This is where you get the updates that matter before they hit your doorstep. Hit that subscribe button right now so you never miss a ruling like this again. Now, to understand why these 8 firearms are in danger, you need a little background. Back in 2022, the Supreme Court handed down one of the most important Second Amendment decisions in American history. The case was New York State Rifle and Pistol Association versus Bruin, and it was decided 6-3. The court said that gun regulations have to be measured against America's deep historical traditions. In plain language, that means if a law restricting firearms has no real connection to the way things worked when the founders wrote the Constitution, that law is probably on shaky ground. Gun rights supporters celebrated. They thought this ruling would wall off future bans and start knocking down the ones already in place. In some courtrooms, it has done exactly that. But in other places, state governments looked at that ruling and decided to push even harder, betting that their own laws could survive the new test. That's where we are today. A legal tug-of-war with your guns caught in the middle. So let's walk through the 8 firearms that are currently banned, newly restricted, or hanging by a thread in multiple states right now. These are real laws, affecting real people, right now in 2026. Start with the one everyone knows first. The AR-15 and its variants are banned from sale, manufacture, and transfer in at least 10 states. California, Illinois, New York, New Jersey, Maryland, Connecticut, Hawaii, Massachusetts, Delaware, and Rhode Island all have laws that make it illegal to buy or sell this rifle. Rhode Island's ban is brand new, signed into law, and set to take effect on July 1st, 2026. If you cross into any of those states today with an AR-15, or if you already own one there, you may be required to register it, restrict how you use it, or eventually give it up entirely. The AR-15 is the most commonly owned rifle in America. There are an estimated 20 million or more of them in civilian hands. That's exactly why it's at the center of this battle. Banning it sends the loudest political signal possible, and that's precisely the point these states are trying to make. The second firearm is the AK-style rifle, meaning the semi-automatic civilian versions of the AK-47 and similar designs. These fall under the same state bans that target the AR-15, but the mechanism differs depending on where you live. California's law actually names them specifically. New Jersey maintains a prohibited models list and AK pattern rifles are on it. New York uses a feature test, which is where this gets really important for everyday gun owners. The feature test works like this. If your semi-automatic rifle accepts a detachable magazine and also has even a single restricted feature, like a pistol grip, a folding or telescoping stock, or a thumb hole in the stock, your gun is legally classified as an assault weapon, and it's banned. It doesn't have to appear on a list anywhere by name. One feature, one magazine, and you're suddenly in violation of the law. Most people don't realize how easily a standard rifle can cross that line. The third firearm on this list is the semi-automatic pistol with restricted features, and this one catches people completely off guard. New Jersey bans semi-automatic pistols that weigh more than 50 ounces when unloaded. That's not a rifle. That's a handgun. New York and California also apply feature-based restrictions to handguns, meaning that if you've added certain modifications or accessories to your pistol, you may have unknowingly converted it into a prohibited weapon. If you live in one of these states and you've customized your carry pistol, it's worth knowing the exact legal threshold before you find out the hard way. The fourth is the 50 caliber rifle. Illinois, through a law called the Protect Illinois Communities Act, bans not just 50 caliber rifles but also 50 caliber cartridges themselves. California restricts 50 BMG rifles as well. These are specialized, long-range, high-powered firearms. Not exactly what your average weekend shooter is running. But the significance here isn't about how common they are. The significance is that the government drew a line, and drawing that line moves the entire boundary of what's considered acceptable. Once that boundary moves once, it moves again. That's the pattern that gun rights advocates are watching very closely. Before we get to the 2 firearms on this list that almost no one is covering, make sure your notifications are turned on for this channel. When courts issue new decisions on these exact cases, you're going to want to know the same day it happens, not a week later when the damage is already done. Turn those notifications on now. The 5th firearm is the semi-automatic shotgun with certain features. Multiple states have extended their assault weapons bans to cover shotguns that combine a detachable magazine with features like a folding stock, a pistol grip, or a thumbhole design. Delaware's assault weapons law specifically targets these. New York's SAFE Act covers them under the same feature test used for rifles. California has had restrictions on certain semi-automatic shotgun configurations for years. The problem is that these guns are sold completely legally in states without such bans, often marketed specifically as home defense tools. You buy it legally in one state, load it in the trunk, drive to visit family in a restricted state, and now you're holding a prohibited weapon. It happens, and the person it happens to never saw it coming. The 6th firearm is the AR pistol with a stabilizing brace. This one has a complicated recent history. The ATF under a previous administration attempted to reclassify pistol braces as rifle stocks, which would have instantly converted millions of AR pistols into short-barreled rifles, a much more heavily regulated category under federal law. That rule got tied up in federal courts and didn't fully survive. But at the state level, the story is different. California, New York, New Jersey, and several other states have either already folded AR pistols into their assault weapons definitions or have passed separate rules targeting what they called the pistol brace loophole. In a banned state, an AR pistol is usually still a banned weapon, regardless of the brace situation, because the firearm itself triggers either the feature test or a specific named model prohibition. The brace discussion is almost beside the point in those states. The 7th entry isn't a firearm itself, it's a magazine. But the magazine is what makes the gun illegal, and that's exactly why it belongs on this list. California bans magazines that hold more than 10 rounds. Illinois bans magazines over 10 rounds. New York bans magazines over 10 rounds. Colorado bans magazines over 15 rounds. Now here's the trap. Many popular handguns and rifles come from the factory with magazines that exceed those limits. If you live in one of those states and your gun came standard with a 17-round magazine, the weapon you legally purchased is now putting you in violation of the law just by sitting in your nightstand. The magazine acts like a switch that flips your legal firearm into an illegal one. This is one of the most common ways law-abiding gun owners get caught without realizing they've done anything wrong. The 8th firearm, and this is the one that genuinely surprised gun rights attorneys when they read the new law, is the revolving shotgun. Rhode Island's newly signed law, taking effect July 1, 2026, doesn't stop at banning semi-automatic rifles. It specifically names revolving shotguns as prohibited firearms. Not a semi-auto, not an AR-style anything. A revolving shotgun. This is a firearm that almost never comes up in policy debates. Most people couldn't name a single news story about revolving shotguns being used in crimes. And yet there it is in the law, written explicitly. This is what the broadening of these bans looks like in practice. Lawmakers are widening the definitions, expanding the lists, and pulling in firearms that gun owners never imagined would be targeted. The revolving shotgun in Rhode Island is a preview of where this goes next, if nobody pushes back. Now let's look at what this means for your real life. Not in theory, but in 3 situations that are happening to actual gun owners right now. Picture this first scenario. You've spent years in Texas owning your AR-15 legally. You took a new job in New Jersey, packed up your house, and brought your safe right along with you. You kept the rifle stored properly the whole time. The moment that moving truck crossed the New Jersey state line, you became a felon under state law. You hadn't fired the gun. Nobody told you. Your realtor didn't mention it, the movers didn't mention it, and now you're sitting on a criminal charge waiting to happen. This is not a rare edge case. Gun owners' forums and legal defense organizations report this kind of situation regularly. The rule is simple. Before you move to a new state, you look up the gun laws of that state first. not after the moving truck is already unloaded. The second scenario involves a concept most gun owners think protects them, the grandfather clause. In Illinois, if you owned an AR-15 before the Protect Illinois Communities Act passed, you weren't required to immediately give it up. You could register it and keep it. Sounds like protection. But the fine print matters. If you leave Illinois and come back, you may have forfeited your grandfathered status. If a family member handles that registered rifle without going through the proper legal steps, that could qualify as an illegal transfer under the law. If you ever try to sell it, the rules around how that can happen are complicated and easy to get wrong. A grandfather clause doesn't mean you're safe. It means you're navigating a legal minefield that was built specifically around the gun you thought was protected. The third scenario catches people who live in completely free states and think the banned states aren't their problem. You're traveling from Virginia to Pennsylvania with your rifle locked in a case in the trunk, unloaded, following every federal guideline for transporting firearms through multiple states. Your route takes you through Maryland, which has an assault weapons ban. Federal law, specifically the Firearm Owners Protection Act, gives you a legal pass when transporting firearms through a state where they would otherwise be prohibited, but only if you're traveling directly from one legal destination to another. Directly is the word that matters. If you stop overnight in Maryland, if you pull off for an extended detour, if you visit someone along the way, you may lose that federal protection, and state law can step in. Law enforcement in some of these states has made arrests in exactly this type of situation. Plan your route. Know your stops. If you've made it this far, you clearly care about your rights. Make sure you're subscribed and have that notification bell hit, because what comes next in the courts over the next 12 months could rewrite the rules for every gun on this list. Now let's clear up 3 things that are spreading as misinformation online, because believing any of these could genuinely put you in handcuffs. The first false belief is that the Bruen decision already struck down all these state bans and you're automatically protected. That is not how the law works. Bruen created a new standard for judging gun laws. It did not automatically void every state restriction that currently exists. Each ban has to be challenged individually in court. Each challenge has to survive lower courts, survive appeals, and possibly reach the Supreme Court before anything actually changes on the ground. Think of Bruen as a new rule book, but the referee hasn't reviewed every play yet. The bans are still active. The police are still enforcing them. You can still be arrested and charged today under laws that may eventually be struck down years from now. Eventually and today are very different things. The second false belief is that if you can walk into a gun store and see something for sale on the shelf, it must be legal for you to buy it. That assumption is dangerous. Dealers near state lines often primarily serve customers from other states. Some dealers make honest mistakes. Some sell firearms that are legal where the store is located, but restricted in the neighboring state where the buyer lives. The transaction happening on the other side of that counter is not your legal shield. You are personally responsible for knowing your state's laws. The fact that a licensed dealer sold it to you is not a valid defense once you cross back into your home state. Research the law yourself independently before you buy. The third false belief, and this one is the most damaging, is that these laws are aimed at criminals, and since you're a responsible, law-abiding gun owner, you have nothing to fear. That is completely backwards. The people most harmed by these laws are people who bought their firearms legally, stored them safely, never had so much as a parking ticket, and then had the legal definition of their property changed by a new statute. Criminals don't register guns. Criminals don't worry about feature tests or magazine capacity limits. The only people affected by registration requirements and feature-based prohibitions are the people who were already following the rules. If you own a legal firearm in a state where these bans are being pushed, you are the target, not the person planning to misuse a weapon. You. Here's where everything lands. The Second Amendment isn't changing, but the legal environment around it is moving faster than at any point in recent memory. A federal court struck down the D.C. magazine ban earlier this month in March 2026, citing the Bruen standard and ruling that commonly owned magazines are constitutionally protected. That's a real win. Illinois' assault weapons ban is actively being challenged in the Seventh Circuit Court of Appeals, with gun rights groups pushing for Supreme Court intervention. If the Supreme Court eventually decides to take up an assault weapons case directly, it could reshape the legal map for every single state at once. That would be a historic ruling, but it hasn't happened yet. And until it does, you are living under the current law in your state, not the future law that might eventually exist. There's also a massive legal argument building around what the term commonly owned actually means under the Bruen framework. Gun rights lawyers argue that 20 million plus AR-15s in civilian hands makes it the most commonly owned rifle in America, and that it must therefore be constitutionally protected from bans. Anti-gun state attorneys argue that the number of weapons in circulation doesn't matter if the weapon is considered especially dangerous. That debate is going to drive federal court decisions for years. The outcome will determine whether every ban on this list ultimately stands or falls. What you need to carry with you after watching this is simple but critical. Know what your state says about every firearm you own. Know the rules for transporting those firearms through other states. Know what registration requirements apply to grandfathered weapons. Know the magazine limits in every state you travel through. And update that knowledge regularly, because in 2026, these laws are not sitting still. The legal landscape is shifting month to month, and being caught uninformed is being caught off guard. Your rights don't enforce themselves. They never have. The people who wrote the Second Amendment understood that rights on paper only survive when the people holding them stay informed, stay engaged, and refuse to surrender ground through ignorance. You being here watching this, keeping up with these changes, that's what it looks like to actually defend your rights. Don't stop. Subscribe. Share this with someone who owns a firearm in any of the states we covered today. Drop a comment and tell me which one of these 8 surprised you the most, because I read them all, and your voice in this conversation actually matters.